Commissioners Bluestone and Villanueva to join in.
Okay, do we want to go through the members of the public who've joined?
Let's wait for
Okay.
the commissioners.
Okay.
Hey, Ron, are you there?
Just a little bit.
I'm here. I'm moving my computers around here. So.
Morning, Jeff. Morning, Francis.
Good morning.
Morning, everyone.
Morning, everybody. This is Ron.
Morning, Ron.
Good
You're on
morning.
telephone or on Zoom?
I'm on Zoom.
I'm on Zoom.
I'm on Zoom.
Mr. Chairman?
Yes, sir. How you doing, Governor?
Doing well, thank you.
Good.
Nice background on your Zoom.
Thank you. Sonny,
Yeah, I'd
assisted
like
me
to
with
know
that.
how he did that.
Sonny assisted me with finding that the other day, and I thought it was appropriate given all the other circumstances.
Commissioner Villanueva,
But
can
just
you hear
because
us?
I see myself. But I don't see myself. I see Jeremy.
Oh, yes, because he's the one speaking.
Oh, okay.
And yes.
Okay.
Yes, sir.
So let me turn up my body, my eyes.
Great. So Judy is with us.
Have we started?
We haven't started yet. We're
Okay.
still waiting on Commissioner Bluestone.
Okay, I need to run for just a second, please.
Sure.
Sorry, I had an emergency this morning. I'm sorry, guys.
How are you, Judge Judy?
She had to step away.
Okay. Sonny, if you don't mind giving Commissioner Bluestone a call. Okay, thanks. This is by far our best attended commission meeting so far.
Can we see the people who are going to speak from the audience?
When we unmute them and allow their video, Commissioner Williams, yes. But right now, just for security reasons, all members of the public are both muted and can't share their screens.
I just saw that somebody, Ken Resnick, came on. Is he in
Great.
the audience?
He is, but again, he's muted and can't share his screen at the moment. Good morning, Ken.
Gary, I can't see all of your beautiful face.
Was that right? Can you see the top of my head?
I can. It's the same color as mine.
Yeah. Okay, well, I'm at my computer because I need to use it to read all the documents. And so I've got my iPad sitting there. I'll get a little closer.
Oh, there you are. Okay.
Yeah. No, I have my computer on the right here so that I can read the documents.
And we have Brian McHale.
Is it possible that Commissioner Bluestone's joining by phone?
Commissioner Bluestone, if you've joined by phone, please send me a quick text and I'll go through the phone numbers and see if I see you. He was having internet troubles at the house, so it's possible that he has joined by phone. None of the callers, however, are his numbers.
Okay.
Who's Brian McHale?
Commissioner Williams, we'll go through members of the public with a virtual sign-in
no,
sheet
he's-
after we get all the commissioners on board.
Yeah, because he's in one of those little squares. Okay, I'll be here then. Where's Judge Judy?
She stepped aside for a minute.
I'm right here.
Okay.
Good morning, Judy.
Good morning, everyone.
Hi, Judge Judy.
Hello. I have to go grab my beer real quick.
Well, Chair Lang, we have a quorum and it's 5 after 9 and we can't get in touch with Commissioner Bluestone. Should we wait or should we proceed?
I think we should probably go ahead and proceed. Stuart is not one who is given to showing up late, much less not at all. So I'm assuming he's got some sort of technical problem that he will have to figure out to solve, and we'll do so. So
Okay. To let you know, Sonny has texted him and called him and can't get him on the line at the moment. So perhaps he'll join us later.
yeah, I think that's right. Go ahead.
Before you you move on to the roll call, Chair Lang, I'd like just to do a virtual sign-in to go down the roll of all the participants and ask them to identify themselves, to say hello, and to say what organization they're with, if they're with an organization, just so you commissioners know who's listening in and who's joined us. And the line is rather long, so we'll just begin. So, Mr. Antonio Corrales, I'm going to unmute you. Please introduce yourself.
Can you hear me?
Yes.
My name is Antonio Corrales. I work for State Auditor Brian Cool.
Okay, thank you. Mr. Brian McHale.
Good morning, everyone. This is Brian McHale. I'm the compliance supervisor with the Philadelphia Board of Ethics, and I was joining this meeting because we're planning a Zoom meeting of our own board in a couple weeks, and yours was the first one of a similar agency that was blazing this trail for us. So I wanted to check in and see how it went.
Fantastic. Welcome to New Mexico.
Thank you.
Mr. Cliff Rees, back from Japan.
Yes, I am. Good morning, commissioners, and good morning, Jeremy. Cliff Rees, retired state government attorney in Santa Fe. I am currently a consultant to the commission on procurement ethics issues.
Thank you. Ms. Heather Ballas.
Good morning, commissioners. Heather Ballas with the Thornburg Foundation. Happy that you all were able to continue to do this meeting. Thanks for your service.
Ms. Hernermund.
Good morning. I'm Heather Hennerman with the New Mexico Coalition for Literacy. Also appreciate the fact that you can continue, pardon me, and appreciate the listening also. Thank you.
Thank you for joining. Mr. Ivan Eshelman.
Yes, I'm attending as a citizen. I am a member of the League of Women Voters.
Thank you. Thank you for joining. Mr. John Verhule.
Good morning, Director Ferris and members of the commission. My name is John Verhule. I'm an attorney with the New Mexico Environment Department.
Great, thank you. Mr. Resnick.
Hi, this is Ken Resnick. Good morning. I'm not associated with any organization, just a member of the public of New Mexico.
Thank you for attending again, Mr. Resnick. Mr. Towery.
Good morning. My name is Lane Towery. I am a law student at the University of New Mexico and a soon-to-be summer intern with the commission.
Thank you, Mr. Towery. Ms. Sanchez Eastwood.
Good morning, Melanie Sanchez Eastwood with New Mexico First and also the New Mexicans for Ethics Coalition.
Thank you for joining us. Mr. Biederman. Mr. Biederman.
Can you hear me now?
I can.
Okay. Paul Biederman, I'm a consultant to the commission working on the code of conduct at this point, model code of conduct.
Thank you, Mr. Biederman. Mr. Lopez.
Yes, this is Sammy Lopez. I'm the Executive Director for the New Mexico Press Association.
Thank you, Mr. Lopez. Ms. Tellez.
Good morning, everybody. This is Sydney Tellez with Common Cause New Mexico and also with the New Mexicans for Ethics Coalition.
Thank you, Ms. Tellez. Okay, I'm going to now move to folks who aren't identified through Zoom, but whose phone numbers have dialed in. So number 505-331-4735. Please identify yourself.
Hi, this is Dan McKay. I'm a reporter with the Albuquerque Journal, and I'm just observing as part of my job and as a member of the public.
Thank you, Mr. McKay. Okay, 505-459-4587.
Hi, this is Melanie Majors with the New Mexico Foundation for Open Government.
Ms. Majors, thank you for joining us.
Thank you.
There he is.
And 505-681-7994.
This is Deborah Condit with Common Cause New Mexico.
Thank you, Ms. Condit. And then we have one person who's joined by an unidentified iPad, and I think it might be Tony Ortiz.
Jeremy, that's right. This is Tony. Good morning to everybody, and thank you for this opportunity.
Great, thanks, Mr. Ortiz. And I believe that Commissioner Bluestone has now joined us. Commissioner Bluestone?
Good morning, everybody. I'm happy to be here. Thank you. Sorry for
Great.
being a few minutes late.
And having gone through the virtual roll call, all members of the public, I want to remind you that to try to prevent some of the unfortunate events that happened with the PRC yesterday and Zoom bombings around the country, we've got rather tight controls here. So you're all on mute, and you shouldn't be able to share your screens, and that should be the case with any member of the public that joins. Once we get to the public comment period, we'll go through some procedures and remind you how to raise your hand virtually through Zoom. And in the public comment period, each of you will have an opportunity to participate in public comment. But until then, we have an agenda to go through the agendas available on our website if you'd like to pull it up alongside. And we'll also be going into executive session upon a motion later in the meeting. And when we do that, what we'll do is the commissioners and the commission staff will go into a breakout room, as it were, and the members of the public will remain in the room that you're currently in. And so with that, Chair Lang, I believe it's time to call the roll.
And thank you, Jeremy and Walker and Sunny, for all of the good lessons you have given us to bring this meeting to fruition today. Okay, so I will call the roll in alphabetical order, which is essentially the way I will proceed, with the exception of myself being last. Commissioner Baker.
Present.
Commissioner Bluestone.
Here, although I'm jealous about the background that you have there, Chairman.
Sonny likes me more than he likes you, apparently. Commissioner Carruthers.
Present.
Commissioner Solomon.
Commissioner Solomon, you'll have to unmute yourself.
I'm present.
Thank you. Commissioner Villanueva.
Same with you, Commissioner Villanueva.
Judy. Do you see her, Jeremy?
Well, I don't see video. She has muted herself.
No, you have me muted.
Okay, you're
There you go.
unmuted.
You have
You're
me
unmuted.
muted. Okay. Thank you.
That qualifies as a here. Mr. Williams. Commissioner Williams is present. I can see her.
Yes, this is, I am very present.
Yes, you are. And Chair is also present. So we have a full commission today. The next matter is approval of the agenda. Has everybody looked it over? And if so, is there a motion to approve?
So moved.
Moved by Williams, is there a second?
Second.
Okay, and Jeremy and I have discussed this. We're going to have to go through the tedium of roll call votes on everything. Commissioner Baker?
Yes.
Approved. Commissioner Bluestone?
Yes.
Commissioner Carruthers?
Yes.
Mr. Solomon? Commissioner Villanueva?
Yes.
Commissioner Williams?
Yes.
Okay, so the motion is approved. Next is approval of the minutes of the February 7th commission meeting. Has everybody had a chance to look them over?
Yes.
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 Okay, are there any suggested modifications, amendments, corrections? Hearing none, Chair will entertain a motion.
Move approval.
Second.
Okay, moved and seconded. Commissioner Baker?
Yes.
Mr. Bluestone?
Yes.
Mr. Carruthers?
Yes.
Mr. Solomon?
I abstain, Mr. Chairman. I was not present for the February 7th meeting.
Thank you, Commissioner. Commissioner Villanueva?
Yes.
Commissioner Williams?
Yes.
Chair votes yes. The minutes of the February 7th commission meeting are approved. All right, Jeremy, I'm going to turn it over to you now for operations and legislative updates.
Thank you, Chair Lang. I have 4 categories of updates. As I go through each of the categories, I'll pause and then Chair Lang ask you to ask the commissioners if there are any questions that I can respond to seriatim. So I'll just start with the commission's current response to the COVID-19 pandemic. This is the end of our 3rd week of telework. It was relatively easy for the commission to the commission staff to transfer over to telework. All of the commission staff have mobile phones. All of our files are on the cloud. We got a Zoom account together relatively soon after we moved to telework, and we've been having daily Zoom commission meetings, commission staff meetings. So that the transition for the State Ethics Commission was quite simple. We're a small and new and nimble agency. Next, we've posted on the website a lengthy memorandum explaining why, under our view of the Open Meetings Act, commission virtual meetings under Zoom are permissible, and laying out the legal foundation for the commission's ability to meet virtually through Zoom. So that's there for the public to see. That's located on the same transparency page that the agenda and the details for this meeting are located. And then following on to that, I, as executive director, pursuant to the powers in the rules 1.8.3 NMAC, have issued 2 standing orders. The first is to direct parties that are appearing before the commission to appear before the commission by way of Zoom. And that's part of the legal foundation for the Zoom meetings and the commission's kind of virtual meetings. And second, I've also issued a standing order that allows parties in administrative cases before the commission to receive 21-day extensions to filing deadlines upon request. We want to be accommodating because we're unsure of the delays that this is causing for the General Service Department and Risk Management as they assign counsel to cases and complaints before the commission. And we want to accommodate the law firms that are struggling with this period as well. And with that, Chair Lang, that's the updates for the COVID-19 response.
Thank you. Commissioner Baker, do you have any questions?
No, sir.
Commissioner Bluestone?
No, sir.
Commissioner Carruthers?
No.
Mr. Solomon?
No, Mr. Chairman.
Thank you. Commissioner Villanueva?
Oh, yes.
Do you have any questions?
No, I don't. Thank you.
Thank you, Judy. Commissioner Williams?
No, no questions.
Thank you. Okay, on to the next matter. This will be, well, no, we still got other stuff. Go ahead, Jeremy.
Yeah, so my next update, Chair Lang, is with respect to the State v. Padilla case and the Commission's quarterly report. So with respect to the State v. Padilla case, at the last Commission meeting, we discussed the Commission's filing of a motion for leave to file an amicus curiae brief with the Court of Appeals in that pending appellate matter. The Commission staff prepared and filed that motion and also filed our proposed amicus brief. Ms. Padilla's attorney, Paul Kennedy, opposed that brief and the motion for leave to file it. The Court of Appeals granted the Commission's motion and allowed the filing of the brief and has accepted the Commission's amicus brief into the case. And that's kind of now where the Commission sits in that particular appellate matter. If Ms. Padilla responds to our amicus brief, which I anticipate Ms. Padilla will through her attorney, Mr. Kennedy, then we'll consider filing a reply brief. But this is pretty much the extent, the filing of the amicus brief and having accepted is pretty much the extent of the Commission's participation in this case so far. And we, your attorneys have represented the Commission's position in that case. If ultimately the Court of Appeals rules in Ms. Padilla's favor and holds that those particular sections of the Governmental Conduct Act 1016-3 are either don't create statutory duties that are incumbent upon public officials, or even if they do, if they're unconstitutionally vague, then the Commission will pivot and think about legislative amendments to respond in the next long session, amendments to the Governmental Conduct Act. And if the the court responds in a way that rules in a manner that's suggested by the commission in its amicus brief or by the state through the Attorney General's brief, then I hope the commission's brief will have helped the court. So that's the updates on the State v. Padilla matter. Next, the commission has also published. I'm sorry, Commissioner Williams, I'm not quite done with my updates here. Next, the quarterly report. Our first quarterly report was published yesterday, or rather 2 days ago. And under statute, the Ethics Commission is required to give a kind of a bare bones report on administrative complaints filed with the commission every quarter. The number of complaints filed or referred to the commission, the disposition of those complaints, and the types of violations alleged. And in our first quarter from January through the end of March, 6 complaints were filed with the commission. Currently, I believe 2 of them have been referred and 4 are currently under review for jurisdiction. And that includes the briefing that the parties have an opportunity to present to the commission with respect to jurisdiction. And so far, 3 of those complaints have been substantially Governmental Conduct Act cases. 1 presents an anti-donation clause claim, and 2 of the complaints present other types of claims that don't fall within the statutes that are within the commission's jurisdiction. And with that, Chair Lang, that's my updates on the State v. Padilla matter and the quarterly report.
Thank you. Commissioner Baker, any questions?
No.
Mr. Bluestone?
Just one question, Mr. Chairman, with respect to the State v. Padilla case. If the response in opposition is due on April 30, do we know when or we'll get a chance to reply and when that would be due?
Commissioner Chair Lang and Commissioner Bluestone, I believe that the commission doesn't have a right to reply under the rules of appellate procedure. We would have to file a motion for leave to file a reply upon good cause and attach the reply brief thereto. And so we would, at that juncture, consider the response and prepare the motion papers. And I believe that I haven't consulted the rules of appellate procedure on this morning, but I believe that motion for leave to file would be due within 7 or 10 days.
Thank you.
Commissioner Carruthers?
No questions.
Commissioner Solomon?
No questions, Mr. Chairman.
Commissioner Villanueva? Commissioner Villanueva, do you have any questions?
No questions.
Thank you. Commissioner Williams?
Yeah. Well, I just needed a little refresher here about this appeal. So we've asked to be a friend of the court, amicus curiae. Does that mean to be a friend of the court?
Chair Lang and Commissioner Williams, yes, we filed a motion to be a friend of the court, and the court granted that motion.
And specifically, was it on the Government Conduct Act?
Chair Lang and Commissioner Williams, yes, the case and the commission's brief concerns the enforceability of Section 10(16)(3) of the Governmental Conduct Act, particularly subsections B and C.
Okay, thank you.
Thank you. Okay, ready to move on to the next item?
Yes, sir. Chair Lang, the next item for updates involves rulemakings that the commission the commission staff are working on for potential issuance for public comment at the next commission meeting, which I anticipate will be in June. There are three rulemakings that we're currently working on. The first is the proposed code of ethics, which we discussed at the last commission meeting. Under statute, the commission has an obligation to produce a proposed model code of ethics and distribute it to the other state agencies. The commission staff have been working with both Paul Biederman and Cliff Reese on the development of that model code, both in terms of its content and format. And I would like Mr. Biederman, who's the main contractor on the project, just to provide a very brief update to the commission on the work so far. So Mr. Biederman, you're unmuted.
Okay, sorry. Yes, thank you. I've been putting in time and consulting with Mr. Reese. Am I being heard?
Yes.
Okay, I wasn't sure. We've been trying to develop a code that would be understandable to state employees, whatever level of education, so that it gives them guidance. And in particular, the more we look into this, the more we realize that the ethics rules that are in state law are really scattered over quite a few different locations. I found about 9 different statutes and constitutional provisions, for example, relating to gifts. So I'm trying to compress those all into a single area, a single rule, and make it understandable without becoming oppressive and difficult to penetrate. And also looking at trying to cover the field of ethics laws and rules, but also go beyond the laws. We're trying to establish something that where we offer to the agencies. Let me just backtrack on that for a moment to remind you that most agencies are not required to adopt any code at all. Many do, but only the statewide elected officers, the 7 really, who have offices are actually required to adopt a code of ethics from the Governmental Conduct Act. Any other agency has the option to do so, but not an obligation. So what I'm trying to do is develop something that would be adopted by the agencies and that they would want to have as a good compilation of all the different ethics requirements, and go beyond just the basic standards that are in the law. There are some standards that we feel are really so lenient that they really don't have the impact that they intend. And we want to offer the agencies the opportunity to accept stronger standards, which we believe they can. So that's a quick update.
Thank you, Mr. Biederman. And to remind the commissioners, under the timeline that you adopted at the last commission meeting for this project, the staff and Mr. Reese and Mr. Biederman will provide to you a complete draft of the model code by middle May, which will provide you a few weeks to review it before the June meeting. And at the June meeting, the plan is to issue the draft model code for public comment. And then later in the August meeting, we would actually have a rule hearing on this particular rule. So there's two other rule makings that I want to discuss. The second, which is not on the agenda for today as a particular item, it's just something that we're beginning to work on, is a rule also that we would like to go in parallel with the model code rulemaking timeline, which means it would be issued at the next commission meeting, and then a rulemaking hearing, a formal rulemaking hearing would happen in August. A rule that would be added to 1.8.1 NMAC to govern commission meetings. And the idea of that rulemaking would be to kind of further solidify in rule the commission's power to meet virtually and not just through the standing order and what's implicit in the Open Meetings Act, but to add a little bit more legal foundation and also govern particular commissioners' actions when they participate telephonically when the commission is meeting face-to-face. So we're working on that rule. It's been, early drafts have been distributed to you as part of the SEC bi-weeklies, and that's part of also what we're doing in the rulemaking work. And then finally, something that is on the meeting agenda for discussion later is the rulemaking on the informal advisory opinions or the expedited advisory opinions process that we're hoping to put together. And that also should, in terms of timeline, should travel with the proposed Code of Ethics project, which means, again, a final draft would be sent to you by middle May. In June, it would be discussed and issued for public comment, and in August, there would be a formal rulemaking. And with that, Chair Lang, that's my updates on potential rulemakings.
Any questions, Commissioner Baker?
No, sir.
Mr. Bluestone?
No, thank you.
Commissioner Carruthers?
No.
Commissioner Solomon?
No, Mr. Chairman, thank you.
Thank you. Commissioner Villanueva?
No.
Thank you. Commissioner Williams?
I have some questions. On this proposed code of ethics, when we developed this proposed, the code of ethics, did I understand that there are some agencies that don't have to accept it? Or when the code of ethics is written and approved, do all agencies have to accept it?
Chair Lang and Commissioner Williams, under the statute, no agency has to accept the proposed Code of Ethics that the State Ethics Commission issues. The State Ethics Commission does not have the statutory rulemaking power to create a code of conduct or a code of ethics and have that binding on any other state agencies. Under the Governmental Conduct Act, the legislature has required state agencies that have elected state officials to adopt codes of conduct. And under the Governmental Conduct Act, the codes of conduct that those state agencies have to adopt and any other state agencies also have the discretion to adopt codes of conduct. Under the Governmental Conduct Act, state agencies can adopt codes that are more stringent than the requirements of the Governmental Conduct Act. What the State Ethics Commission is doing in its rulemaking is providing a model code, and the extent that the State Ethics Commission's rulemaking power reaches is if any other state agency creates a code of conduct or adopts a code of conduct, they have to consider the State Ethics Commission's proposed code of conduct when doing so, but they don't have to adopt the Ethics Commission's code of conduct.
So if an agency writes their own code of ethics, does that have to have approval from anyone other than that state agency? And who monitors the effectiveness of the state agency's code of conduct?
Chair Lang and Commissioner Williams, the State Ethics Commission does not have the power to review those codes of conduct. If it's a state agency within the governor's cabinet, I would think that the governor ultimately has the power to review those codes and change them, given the kind of executive power that the governor has over the administrative agencies in her cabinet. Ultimately, I would think that the State Personnel Board likely also has some type of review power in the way that it might make determinations based on discipline that agencies issue based on violations of their codes of conduct. And again, any decision that the State Personnel Board would make is ultimately reviewable by the state district courts on appeal and then further up into the courts. And so that's kind of the review structure for these codes of conduct that the agencies issue.
Well, is it possible that there can be a statute developed to make all agencies have the same code of conduct, where this code of conduct that is written by us will be mandated to all state agencies?
Chair Lang and Commissioner Williams, that would require a statutory change either to the Governmental Conduct Act or to the State Ethics Commission Act to give the Ethics Commission that rulemaking power. You can think of the Governmental Conduct Act as a kind of code of conduct that applies to all state agencies. But beyond that, the Ethics Commission doesn't have the rulemaking power to bind other state agencies, and it would require the legislature to amend either the Governmental Conduct Act or the State Ethics Commission Act to grant the commission that power.
Well, it seems to me like this is so scattered. And if we go through all the drills of doing a code of ethics for the state, it should seem to me that it should be mandated to all state agencies. That's just my thoughts on it, because it's confusing to know, well, this one can do it and that one can't do it. And then do we have the power if they don't accept it? How can they be prosecuted if they violate the code of ethics when they haven't issued or adopted the code of ethics? So I have a concern about that.
Chair Lang and Commissioner Williams, we're hoping to write such a brilliant code that the other state agencies will be persuaded to adopt it.
There's the answer. Great.
Okay.
All right. Thank you. Anything else, Commissioner Williams?
No. Well, I do have a question on the rule on expedited written advice. I didn't quite explain why you needed this or what it was. So you're saying
Chair
that,
Lang and Commissioner Williams, I believe that will be an agenda item later in the meeting.
okay, thank you.
Thank you. Jeremy, next.
Yes, thanks, Chair Lang. And finally, the final piece of update that I have for the commission is with respect to budget and hiring items. The commission's supplemental appropriation of $200,000 for the rest of fiscal year 20 has now been allotted by the State Budget Division, and we now have authority to expend that money, and we are working to do so and to get our contracts both with Mr. Biederman, Mr. Reese, Real Time Solutions, who's developing the commission's online complaint filing and docket application. We're working to get all of those contracts in place. We're also working to expend the funds on other basic capital infrastructure that we need, computers, furniture, etc. So that's in the works. I'm sure that you've all been following the economic fallout, both from the fallout of OPEC Plus and oil production and the effect that's having on the Permian and on the state, in addition to the decline in demand because of the pandemic. That's likely going to precipitate a special session this summer, which will likely have an effect on the Commission's FY21 budget. And we're thinking about how to get at least the fourth position that we currently have funding for in our FY20 monies filled before vacancies are frozen and the commission would be restricted from additional hires. So we're monitoring that daily, and we'll be nimble in how we respond. Second, with respect to the hiring of a finance and administrative director, we have finally gotten SPO to create that job posting for us and have it correctly indicate that the job is for Albuquerque and not for Santa Fe. That job posting is now up on the state personnel office's website. It's available to all state employees through SHARE. I've also shared it with the New Mexico Public Procurement Association. It's also on their website. And so the application period is open for a few weeks. And once SPO accumulates all of the applications and reviews them for minimum qualifications, they'll send them over to us, and we'll begin to conduct interviews and hire for that position, hopefully within the next 3 or 4 weeks. Next, we're bringing on 2 summer interns this summer, Miss Ann Swift and Mr. Lane Towery. We're bringing them on not as temporary employees, but as contractors, and they've already submitted their W-9s to the state and are ready to join us this summer, and we're greatly looking forward to their help. there's a number of projects that they can help Walker and Sunny on with respect to the upcoming legislative session. And finally, Chair Lang and Commissioners, we're beginning to move toward a lease for the adjacent office suite. We're currently in Suite 217 of UNM Science and Technology Park Bradbury Building. The office suite that's just adjacent to us is a better long-term position or for the commission and the commission staff. And so we're taking the steps now to move toward that office suite. We have to work with GSD's Facilities Management Division for approval, but we're working on a lease with UNM to move over into that office. And it's something that's well within the commission's budget, even anticipating reductions in the FY21 special session or special session for FY21. And with that, Chair Lang, those are my updates to the budget and hiring items.
Thank you. Anything on that, Commissioner Baker?
No, sir.
Commissioner Bluestone?
Just one question, Jeremy. I'm curious about how you reached out to law students to determine the 2 interns who you ended up making offers to and hiring.
Chair Lang and Commissioner Bluestone, you may know that our General Counsel, Mr. Boyd, is I suppose an adjunct faculty member or a contractor faculty member. He teaches the law review course at UNM, and so has a good relationship with UNM Law School, and posted at UNM Law an advertisement for law students at UNM to apply to be summer interns. We received I don't know, 8 to 10 applications, reviewed them, conducted interviews, and after those interviews decided to bring on Ms. Swift and Mr. Towery. Mr. Towery, in fact, wrote his law review comment on the State Ethics Commission Act. He's a current 2L, and Ms. Swift is currently finishing her 1L. And that's how it was decided. Walker, if you would like to add anything to that, feel free.
The only thing I'll add is that I worked with the Career Services Office at the School of Law to have a posting that was sent to all of the law students' email accounts. I separately forwarded the job posting to members of the staff of the New Mexico Law Review, and asked for any interested parties to submit applications.
Thank you. I appreciate the openness of the search that was done. Thanks for telling us.
Thank you.
I have a question.
Hold on, we'll get to you. Commissioner Carruthers?
No questions.
Commissioner Solomon?
No questions, Mr. Chairman.
Thank you. Commissioner Villanueva?
I have 2 questions, please.
Please, go ahead, Judy.
All right, Mr. Director, I think at first, with respect to that position you're going to hire, did you start that position as a financial position and then move it to an administrative position, an AO1?
Chair Lang and Commissioner Villanueva, the State Personnel Office declined our request to add an AO1. What we've added is the classified position that's kind of directly beneath that in the structure. Is called a staff manager position. So as it's understood in the classified employee structure and by State Personnel Office, we're hiring a staff manager. But what we're calling this position internally is the Director of Finance and Administration. And this position's responsibilities include budgeting and financial tasks, in addition to the very small HR tasks or few HR tasks that this person will have to carry for the commission staff, given its small size.
Okay, thank you, Mr. Director. Thank you. And I just wanted to make one comment. I appreciate you sending over that paper that was done by that was written by Lane Towery. I encourage the other commissioners to look at that. It was very well done. Congratulations to you, Mr. Towery.
Great, thank you, Mr. Towery.
Agreed, and thank you, Commissioner Villanueva. Okay, Commissioner Williams?
Yeah, I have several questions. The job that apparently you were recruiting for. Initially, you called them externs. I didn't know what an extern was, and then it became interns. What is the difference?
Chair Ling and Commissioner Williams, I've often wondered that myself. When I was in law school, I think we just called everybody a summer associate, but having come to New Mexico, I've come across both the intern and extern parlance, and I'm not quite sure what the difference is.
And for these interns, did they necessarily have to have a law background, or is this a job that could be done by anybody with administrative skills?
Chair Ling and Commissioner Williams, we specifically were looking for law students, summer temporary workers, interns, externs, associates, because as you well know, the commission's work is deeply legal, and we think that it makes sense to begin to form a relationship with the UNM Law School and to begin to produce a very small section of the New Mexico bar that has a good degree of familiarity with the State Ethics Commission.
Well, I was looking at, you did hire a man and a woman, is that correct?
Chair Lang and Commissioner Williams, yes, it is.
Yes, and may I know their race or ethnicity?
Chair Lang and Commissioner Williams, I'm not sure that I know those details to provide them. I believe Mr. Towery is of, I guess he's Anglo, and Ms. Swift, I'm not entirely certain.
Okay. Well, I'm just concerned about the ethnicity and racial makeup of our staff. So that's why I asked the question. Thank you.
Anything
Chair
else?
Lang, that's all of my updates.
Okay. Thank you very much. Are we ready to move on to Mr. Boyd?
Chair Lang, yes. Before we do that, with respect to advisory opinion 2020-002, before Mr. Boyd provides an overview of this advisory opinion, I want to let the commissioners know that the draft opinion that I circulated yesterday did not include Commissioner Bluestone's recusal to this matter, although it included his notice of recusal. And on the official advisory opinion that we would post, if the commission adopts it, it does indicate Commissioner Bluestone's recusal. And I see that Commissioner Bluestone is raising his hand at this point.
Commissioner Bluestone?
Thank you. No, I just wanted to thank Jeremy for taking care of that and following up. And I will be recusing because I'm on the board of that nonprofit environmental law firm that's the subject of the being the employer of the former employee at issue. So I will just listen in, but I'm not participating, and my recusal will be publicly noted. And I just thank Jeremy for his help.
Thank you, Commissioner Bluestone. I would also remind everybody, while we're discussing anything pertaining to any advisory opinions, please take pains and great care not to mention the requester's names. It's important that we honor that portion of the statute and of the rules. So please try to remember that. Thank you.
I have a question.
Okay. Are you ready to take a question, Jeremy?
If it's respect to that on that point, Judge.
Yes, Commissioner Williams, go ahead.
Well, I just wonder on one of the complaints we had, can I mention the respondent's name?
Chair Lang and Commissioner Williams, the discussion of the complaints is for the executive session only if the commission moves into executive session on a motion. So I would encourage you not to mention anything about any complaints at the moment.
Well, I just wanted to know how I could recuse myself from one of those issues or complaints.
Thank you. And Chair Lang and Commissioner Williams, when the commission goes to executive session to deal with complaints, we can discuss that at that juncture.
Thank you.
I'd just like to add also that the this meeting is being recorded, and we'll be posting it, save the executive session on the commission's website. So that's the other reason to be especially circumspect about the identities of requesters and the parties to administrative complaints.
Thank you.
And with that, Chair Lang, I'd like to turn it over to Mr. Boyd to introduce the advisory opinion.
Yes, go ahead, Mr. Boyd.
Thank you, Chair Lang and Director Ferris. The second advisory opinion that the staff has prepared for the commission's consideration addresses Section 1016(8)B of the Governmental Conduct Act chiefly. The request asks the commission to determine whether a former state agency attorney is prohibited from representing Nuclear Watch New Mexico in federal district court litigation surrounding a consent decree that the attorney was involved in negotiating and executing while serving with as a staff attorney with the New Mexico Environment Department. I won't go into too much detail. You all have had a chance to review the draft that we submitted. The two main points to cover and that the advisory opinion covers are one, the section of the Governmental Conduct Act at issue, Section 8B, is modeled on the rule of professional conduct 16109 that deals with former government attorneys. And so the commission in the proposed draft opinion kind of says that in interpreting the Governmental Conduct Act's revolving door rule, we're going to look to the rule of professional conduct and court cases that have interpreted that rule in guiding our own analysis of that statute. The second thing that the opinion does is it says that we're not going to offer an opinion about the rules of professional conduct governing attorneys, and that's because the State Ethics Commission does not have jurisdiction to enforce those rules against attorneys. And so the staff has sort of reached the consensus that it's best just to not offer an opinion where the commission would have no power to act on an administrative complaint or in a lawsuit. So those are the two main points. The proposed draft, the proposed advisory opinion concludes that the former Environment Department attorney is indeed precluded from serving as an attorney for Nuclear Watch New Mexico in the federal district court litigation, because Nuclear Watch New Mexico's claims arise from and relate to the consent decree that this attorney was intimately involved with preparing and getting entered some years ago. So that's kind of the overview of the opinion. I don't want to take up too much time. We're already we're approaching 10 a.m., but I'd like to turn it over for any questions if there are some.
Thank you, Walker. Okay, Commissioner Baker.
This is an advisory opinion.
Correct. Chair Lang and Commissioner Baker, yes, this is an advisory opinion.
And what's your sense of what's going to happen after the advisory opinion is sent to the folks who requested it?
Chair Lang and Commissioner Baker, I don't know what will happen. My feeling is that, as you can probably tell from the request, this is the subject of some dispute in the ongoing federal district court litigation, and so I could see this being used by one of the parties as a way to try and resolve what seems to be an ongoing dispute. But I don't pretend to know what will, and certainly the request does not make clear what the opinion will be used for.
And the reason I'm asking is, presumably, if the parties cannot agree, the judge will make a decision, correct?
Chair Lang and Commissioner Baker, on a motion to disqualify, yes, the judge will have to make a call. However, I will note that the attorney, according to the request, has not entered an appearance in the litigation. So I don't know what the exact procedural posture of the case is today. I have not checked the docket today, but I would imagine that the attorney that's the subject of the request would need to enter an appearance on behalf of Nuclear Watch New Mexico in order for a motion to disqualify to be ripe.
Understood. And so that takes me to my real question and your decision not to render an opinion regarding the rules of professional conduct. I appreciate the fact that the Ethics Commission has no authority to enforce those rules. If there's a problem that will get to the Office of Disciplinary Counsel, they have their own procedures. But just as we are going to be giving advice in ongoing litigation over which we have no authority or ability to force people to do something or not do something, I'm wondering if it might be appropriate in the right case to give advice where a lawyer's ethical behavior is at issue. I don't want to be throwing more onto your plate, especially when we have no power to enforce it. But I'm just wondering, in terms of a hard and fast rule of never offering an opinion when there's an allegation that a lawyer has crossed the line with respect to the rules of professional conduct.
Chair Lang and Commissioner Baker, I would defer to Director Ferris on what the precedential effect of this opinion is. I believe that in the right circumstances we can take a different course of action. However, we do have jurisdiction to enforce Section 8B, which covers former government attorneys, and I do think that turning us in, I would say, from my perspective, beginning to offer advice on the rules of professional conduct to attorneys would significantly expand our portfolio and perhaps raises a potential for conflict in viewpoints between the State Ethics Commission and the state bar, which ultimately issues advisory opinions to lawyers on ethics issues.
And to follow on that, Chair Lang and Commissioner Baker, I would encourage the Commission not to issue advisory opinions on the rules of professional conduct. Out of an abundance of caution for the separations of powers and the Supreme Court's sphere of regulation in that regard, the Commission wouldn't want to issue an ultra-virus opinion, nor would it want to issue an opinion that would ultimately be inconsistent with something that either the disciplinary board or the Supreme Court would issue on review of a disciplinary board procedure. I think that there are enough attorneys in the state and that fall within the provisions of the Governmental Conduct Act's sections as they relate to government attorneys to give the Commission plenty of work with respect to government attorney ethics. But again, for kind of separation of powers and ultra-virus reasons, Chair Lang and Commissioner Baker, I would encourage the Commission not to wade into interpretations on the rules of professional conduct.
Thank you.
I would add one more thing, and that is that although this could be the subject of a motion to disqualify in the ongoing federal court litigation, given our answer, it could also be the subject of an ethics complaint that the Commission would be tasked with enforcing, since we do have jurisdiction to enforce the Governmental Conduct Act. And given our answer, that would be another avenue for this to proceed.
Thank you. Commissioner Bluestone, I'm going to skip over you. Commissioner Carruthers, anything?
Well, I was just looking at the answer given. Thank you, Mr. Chairman. The answer was yes, this is really a violation of ethical conduct as I'm reading it. Oh, by the way, we don't want to opine on this thing. It seems to me like the usefulness of the Commission as we develop and grow over time is we're going to have to become a little more useful than just saying, yeah, I think this may be a real problem. We don't want to opine on that at the moment. And I don't know what the reluctance is, but I think the people in New Mexico are looking for perhaps a little more clarity and a little more aggressive action than this particular document reveals to me. So just a point, and I'm just reading here from the answer, in view of the facts of request, it says, bars the lawyer from representing nuclear watching on. So that seems like a fairly clear-cut statement. And then the next statement says, the commission declines to opine on whether facts alleged established. And I think we're beginning to develop a convenient habit of dodging ethical questions by saying that's not our authority. We don't have the authority to enforce that. And so we need to be keeping perhaps a list of ethical questions that if you're worried about the authority we have, then we may ask for a change of authority. But at the end of the day, we're not going to be very useful to anybody if we just keep dodging by saying, well, we don't have the authority to enforce that. Do we have the authority to opine? I think we ought to. My point.
So Chair Lang and Governor Carruthers, the point I would make in response to that is the opinion does say that there is a violation of the Governmental Conduct Act, and that would be enforceable by the commission in an ethics, if an ethics complaint were brought. We would be able to assess, the commission would be able to assess penalties if it determined that those were appropriate, and perhaps file a court action seeking to bar the attorney at issue from representing Nuclear Watch if he or she did go ahead and do that. So the opinion is, I suppose, clear in that respect. The second part of the answer, which says that we're not going to, or which says the commission is not going to opine on Rule 16-109. Again, that goes to the point that Director Ferris was making earlier, which is that ultimately the New Mexico Supreme Court enforces those rules, and unless we have authority to do that, it's difficult to see what our business is there. Now, I will say that in this particular case, it doesn't matter too much because there's a significant degree of overlap between the Governmental Conduct Act section at issue and the corresponding rule of professional conduct that covers attorneys. So in this particular case, we are offering a pretty strident answer on this, that yes, this does violate the rules of ethics dealing with former government attorneys. So that's my answer. I hope that's goes at least to some way towards satisfying your concerns, Commissioner Carruthers.
Mr. Chairman, thank you very much for that answer. I guess I'm just beginning to sense as we develop that the public is expecting perhaps an ethics commission that's a little more aggressive than we're demonstrating at the moment, that we tend to want to hide behind this is something that's not in our authority and therefore we can't talk to you about it or do anything about it. And what I'm suggesting is, as these complaints roll along, we may need to determine that some of this needs to be in our authority, because if it's not in our authority, nothing will happen to this particular complaint. And the people voted large majority to have an ethics commission in anticipation that something would happen other than this is not our authority and therefore we can't address it.
Chair Lang and Commissioner Carruthers, if I may, with respect to a more aggressive stance, that's partly, I think, going to be addressed with the next item on the agenda, which is resolution number 4 regarding investigations and civil litigation.
Thank you, Mr. Chairman. Thank you, Director.
Thank you. Commissioner Solomon? Commissioner Solomon, anything?
No questions, Mr. Chairman. Thank you.
Thank you. Commissioner Villanueva?
Nothing, thank you.
Thank you. Commissioner Williams?
I ditto the remarks made by Governor Carruthers. I agree with him exactly what he said. We have to make sure that the public has confidence in our mission and that we are carrying it out. And I certainly agree with Governor Carruthers' remarks on that. Thank you.
Thank you. I have an observation, and it goes to that point. And perhaps, Mr. Boyd, it would be a drafting issue. As a lawyer, as a former judge, I'm well aware of the Code of Professional Conduct, which ultimately is supervised and enforced by the Supreme Court. It is not simply one agency versus another. There is a code which has been adopted by the Supreme Court, which all lawyers must adhere to. And for us to opine on that, what Jeremy referred to as ultra vires, what in English is basically, it's not so much none of our business as it's not even close to our business. While I think your opinion does a very nice job of setting forth why there is, in this particular instance, a violation of the Governmental Conduct Act, which is clearly with what is anticipated by the legislation that we operate under, as opposed to the entirely different part of the government that deals with lawyer misconduct. I think perhaps an edification rather than a line or two at the end of the conclusion, Walker, might go a long way towards getting what it is we're trying to get out there and meeting, quite honestly, what Governor Carruthers and Ms. Williams are concerned about. And I think we all share that. But this is something that will never be within the purview. The Code of Professional Conduct will never be within the purview of the Ethics Commission. No, maybe a little more elucidation rather than a conclusory statement.
Chair Lang, thank you for that comment. I will I'll take that to heart, and we'll as we proceed with these advisory opinions, we'll make sure that we think more about edification and the public facing nature of these opinions as we write them.
Yeah, thank you. Okay, so is there anything else on that matter, Mr. Boyd?
I have nothing further, Chair Lang. I think the commission does need to take a vote on whether to issue this as an advisory opinion.
Okay. Should this advisory opinion as it's written be issued? Commissioner Baker?
I believe it should.
But Chair Lang, you should seek a motion to adopt the advisory opinion.
Right. I skipped that part. And I don't have a tie on today, Jeremy, so forgive me. Missing some things. Okay, is there a motion to adopt and issue the advisory opinion as written?
So move.
Second.
Thank you. Commissioner Baker?
Yes.
Commissioner Carruthers?
Yes.
Commissioner Solomon?
Yes.
Commissioner Villanueva? Commissioner Villanueva?
She's going on mute. She was unmuted briefly there, but she's back on mute.
Commissioner Villanueva? Commissioner Williams?
Yes.
Okay.
Yes for me.
Thank you, Judy. And chair votes yes. So the motion passes. Thank you. And now let's move on to the next matter, item number 3, which is the second page of the agenda regarding resolution number 4. Gentlemen.
Thank you, Chair Lang. I'll briefly introduce this resolution. Ultimately, we'll be looking for a motion to adopt it. By way of introduction, you'll remember that there are 2 means of enforcing the statutes that the Commission has jurisdiction over. One is the adjudication and enforcement of administrative complaints filed with the Commission. The second method of enforcement is the Commission's own initiation of lawsuits in the New Mexico courts. And this resolution is a policy for how the Commission will go about assessing, investigating, and authorizing lawsuits that will be the Commission against some defendant in the New Mexico state courts. And to briefly walk through this policy, it restates the Commission's authority to initiate civil litigation to enforce the statutes under its jurisdiction. And then it sets out a framework for how the commission staff will conduct assessments and investigations of information that we receive or informal complaints or tips about violations of the statutes within the commission's jurisdiction, Governmental Conduct Act complaints that we hear about, Campaign Reporting Act complaints, Lobbyist Regulation Act complaints. And this framework, it very loosely follows the framework that the Federal Bureau of Investigation conducts before it goes to the U.S. Attorney's Office and presents a case to the U.S. Attorney's Office. So initially, the first step is an assessment. The executive director has to approve the beginning of an assessment. When the staff are conducting an assessment of a potential case, the staff is able to look at any publicly available documents and issue any IPA requests, just as a member of the public could do. An assessment could lead either to a request for the commission to authorize a lawsuit, or it could lead to an investigation, or it could lead to nothing at all. An investigation is the second step in the hierarchy. An investigation requires both the executive director and the general counsel's approval. And in an investigation, the staff can do everything they can do in the assessment phase, but also potentially interview witnesses and attempt to subpoena witnesses that are unwilling to cooperate through the commission's power to request subpoenas. Investigations can result in no action, or investigations can result in requests for the commission to authorize a lawsuit. Either way, the results of an investigation will be documented and presented to the commissioners. And then finally, the policy restates the commission has the power to initiate civil litigation. This policy allows the commission staff to go to the commission and ask for that authorization. And before Chair Lang, I would turn it over to you and the other commissioners. There's just a few cleanups in this document that you've received and that's available in the public materials that we would like to amend. First, in the second whereas clause, there should be a semicolon at the end. The references to April the 4th should be changed to April the 3rd. And then finally, in section 7, paragraph 2, we refer to a venue provision where the commission would file in district court a complaint where the respondent resides. We would just excise those words, where the respondent resides, because at this point we don't want to prejudge a venue question. Questions about the proper venue for these complaints involve a number of different statutes, not just the State Ethics Commission statute, and we don't want to say something in the policy that would be inconsistent with the law of venue that would apply. And with that, Chair Lang, I'd like to turn it over for questions.
Thank you. Commissioner Baker?
No questions.
Commissioner Bluestone?
No questions.
Commissioner Carruthers?
Mr. Chairman, I do have a question. It says investigation or referrals and informal complaints and initiation of civil actions. These complaints are not those that require the certification, the signature of the complainant, and the notarization of the complaint. Are these other complaints other than those that are filed under the current protocol, which does require a complaint, a signature, and notarization of the signature?
Chair Lang and Commissioner Carruthers, that is correct. To initiate an ethics commission proceeding, the complainant has to file on that formal complaint form and has to have it signed and notarized, and that initiates the commission's power as an administrative adjudicatory body. What this policy is for other types of grievances that we hear about, perhaps even anonymously, and allows the commission staff to begin to work up an assessment and an investigation and potentially a civil lawsuit.
Mr. Director, do you find this to be consistent then with the law, in that the requirement was that we had the notarized signature? I like what I see here, because I think the business of the commission obviously will will increase as a result of it, but most people are not inclined to want to.
Chair Langen, Commissioner Carruthers, we are confident that this complies with the law.
I just want to make sure that these are things we hear about or notified about that do not require the official notarized signature.
Chair Langen, Commissioner Carruthers, yes, again, this is a policy for how the commission would begin its own lawsuit in civil court. And it's kind of a completely separate process from the administrative adjudicatory administrative complaint process that we've been discussing and the newspapers have been reporting on. For some time, I've referred to the commission's power to file lawsuits itself as its kind of strongest power, and for some time have suggested that the commission can't really do that until it has a policy like this one in place that spells out what are the steps the commission's going to take in order to file its own lawsuits. And part of what this policy does is also expressly state that the commission won't conduct an investigation or an assessment or file a lawsuit based on anybody's political party or any protected status of anybody. And that's kind of a necessary step that we have to get in place before the commission would ever file a lawsuit.
Anything else, Governor?
Thank you, Mr. Chairman.
Thank you. Commissioner Solomon?
Thank you, Mr. Chairman. Under the Section 5, subparagraph 2, maybe it's just me that is having trouble trying to read this correctly. One, it's just the verbiage there, and then the evolution of a complaint into an involuntary complaint. The way I'm reading this, just so those of you that are struggling to maybe get to this particular provision, it says an administrative complaint that is voluntarily dismissed by the complainant before the commission has an opportunity to act on the complaint may be handled as an informal complaint pursuant to the terms of this policy. So I was just wondering who makes the decision on how that particular complaint evolves into an informal complaint? Does the originator have to indicate that to us, or how is that accomplished?
Chair Ling and Commissioner Solomon, that's a great question. Thank you for asking it. The idea here is if someone files a signed notarized administrative complaint on the form and initiates the commission's power to adjudicate violations of the ethics laws, and suppose that complainant withers in the spotlight of the press, is no longer willing to carry on with the case because of, for whatever reason, personal or the press attention, and they voluntarily withdraw their administrative complaint with the commission. What this particular paragraph says is that from the information that the commission has gathered from that administrative complaint, which had then been withdrawn, the commission staff can conduct an assessment and investigation, and potentially the commission itself could bring a lawsuit. It would no longer be the complainant versus respondent in the State Ethics Commission, but it would have transformed into the State Ethics Commission versus defendant in some New Mexico court. And that's essentially what this particular paragraph is doing.
Okay, thank you, Jeremy. I appreciate it.
Thank you. Commissioner Villanueva?
Okay, I do have a question, please. Mr. Director, are you saying then that the commission becomes the complainant in this case?
Chair Langen and Commissioner Villanueva, technically the commission will become the plaintiff in a civil lawsuit. This is a policy for how the commission becomes a plaintiff in a civil lawsuit in New Mexico court. The terms complainant and respondent are kind of for the proceedings, the administrative proceedings in the State Ethics Commission itself.
I understand. Can you please give us an idea of what that process might look like? So we initiate a complaint, or a complaint is initiated by the commission, and then what happens next? Where does it go?
So Chair Lang and Commissioner Villanueva, this policy is for, again, the initiation of a lawsuit that would be filed with the state courts. Anything that's happening before the commission authorizes that filing of a lawsuit is kind of what this sets out. It's an assessment, it's an investigation, it's things that the commission staff are doing, guided by the terms of this policy, in order to work up a request to the commission to file a lawsuit in state court.
Okay, I understand. Thank you very much.
You're welcome.
Thank you. Commissioner Williams?
Yes, I have several questions. First of all, do we have an impeachment process in New Mexico? I wasn't aware of one.
Chair Lang and Commissioner Williams, yes, the legislature has the impeachment power, and the State Ethics Commission's power in regards to that is the State Ethics Commission can recommend impeachment to the legislature, but only so far as that.
Okay, because I never have heard of anyone being impeached, and I just wondered.
Chair Lang and Commissioner Williams, I don't believe that it's ever happened under the New Mexico Constitution, but there is an impeachment clause in the New Mexico Constitution for the legislature to impeach other officials. There's also the analog for the legislature removing their own members, which is slightly different than the impeachment power. And the State Ethics Commission's role with respect to either is only to recommend.
Let me just make a comment, I think, and the others can correct me. I believe that the legislature did begin impeachment proceedings against the former state treasurer. And I think he resigned before the impeachment proceedings went too far.
Oh, thank you. But a question, under the Governmental Conduct Act, which I show on page 3, it says that we may investigate suspected violations of the Government Conduct Act. How do we go about that? And what is it, how do you suspect or find out about something that you feel we should pursue under this provision?
Chair Lang and Commissioner Williams, there's a number of ways that we could be informed as to a Governmental Conduct Act violation. We could read about it in the paper, we could receive a call, we could receive an email, a tip, someone could come into the office and tell us. Basically every way that we would receive the information other than through a complainant filing a signed notarized complaint.
Oh, and my another question is, you indicate that the State Ethics Commission may institute a civil action if a violation has occurred or to prevent a violation from occurring. I guess I don't understand how you would go about that, to prevent a violation.
Chair Lang and Commissioner Williams, that essentially empowers the commission to ask the court for what's called injunctive relief. So the courts can issue all different kinds of relief, penalties, orders of compensation. But one thing that the courts have the power to do is to tell a defendant to stop doing something, and that's called an injunction. And that provision of the Governmental Conduct Act allows the State Ethics Commission to request a court to tell some public employee to stop doing something.
How did you arrive at the figure of $5,000 as a civil penalty?
Chair Lang and Commissioner Williams, that's a quotation from the Governmental Conduct Act, and that's the legislature that imposed that limit of a penalty on the court. So that's $5,000 is a limit that applies to the courts.
And who determines under Financial Disclosure Act, it says that the Secretary of State may refer a matter to the State Ethics Commission, the Attorney General, or a district attorney for civil, injunctive, or other appropriate order. Well, who determines who gets it?
Chair Lang and Commissioner Williams, the Secretary of State in that instance has the discretion on where they refer complaints to, but I'll remind you that the Ethics Commission has entered into a joint powers agreement with the Secretary of State's office, and we expect to receive referrals from the Secretary of State.
Another question. It says let's see. Well, there's a paragraph B. I have page 5, but it says that it does not include the general counsel. And I guess that's in relation, oh yes. Well, I can't find it right now, but there is a paragraph here, talks about commission means the State Ethics Commission, etc., but it does not include the general counsel. And I wanted to know why not.
The Chair Lang and Commissioner Williams, the definition of commission staff in this policy excludes the general counsel. The idea is that this policy governs, imagine that the state agency, the State Ethics Commission, 5 years from now, maybe in a larger posture with more employees, with more investigative staff, with more lawyer staff, and this policy is meant to guide all of those executive staff members, as it were, the executive director, the other lawyers, the investigators, for how they're conducting assessments and investigations. And if the general counsel is specifically involved, then the policy specifically mentions the general counsel. But as a default, references to the commission staff exclude the general counsel.
And in paragraph F of that same paragraph, what is a natural person? I never heard of that. It says a person means any natural person or organization.
Chair Lang and Commissioner Williams, I believe it just means an individual, a human being.
Okay.
As opposed to a corporation or an LLC.
Thank you, Chair.
Oh, yeah. And then how can you determine, and I have some questions about the investigation and investigators, but how, when you talk about investigations on paragraph 7, how can you determine if there will be an immediate future a violation of the ethics laws? How can you determine that there might be or will be an immediate future will violate the ethics code?
Well,
laws.
Chair Lang and Commissioner Williams, I believe it probably depends on case by case, but if there's a series, if we become informed of a pattern or a series of violations of the laws, then I suppose that's one way of determining whether or not the ethics laws are likely to be violated again or in the near immediate future.
Well, we have talked about, and I understand that as far as investigators are concerned, that we will probably have some contracts to hire investigators. But this also says that the on paragraph 7-3 that the executive director and general counsel, that the prior to initiating an investigation, commission staff must obtain approval from the general counsel. And in reading further, it seems that your staff can do the investigation. It says the commission staff may assess whether a referral or an informal complaint alleges discrimination of laws and so forth. And then, so is your staff qualified to do investigations as well as someone you may hire as an investigator?
Chair Langen and Commissioner Williams, again, imagine this policy not just for the next month or two, but for the next several years, when the State Ethics Commission staff has grown to include investigators, and yes, we will be hiring for staff members that have the qualifications to conduct investigations, and attorneys that would be doing the same.
Okay, but they would be hired as investigators.
Or potentially as attorneys, Commissioner Williams.
One of the things that I would like, because I sort of get lost in the process, and that is after you accept the complaint and then it is given to the general counsel, the process to me is not very clear as to where it goes from there. So I would like to know, if possible, can we have like a flow chart or organizational chart which does show exactly the process after it leaves your office and then it goes to somebody else, a judge or investigator or a hearing officer, etc. I'm just sort of lost in the process.
Chair Lang and Commissioner Williams, I take it that you're asking with respect to administrative complaints that are filed in the State Ethics Commission. And yes, I believe that some of those flow charts have already been worked up. I believe that when the State Ethics Commission Act was being drafted, that several of the drafters had flow charts. And if we don't already have one in our files, we can work one up.
I would appreciate it. Thank you so much. Thank you.
Thank you, Commissioner Williams. Good work, guys. I'm happy with it. I have no questions. Relative to this resolution, the chair will entertain, excuse me, a motion to adopt it.
So moved.
Second.
Thank you. It's been moved and seconded. Commissioner Baker?
Yes.
Commissioner Bluestone?
Yes.
Commissioner Carruthers?
Yes.
Commissioner Solomon?
Yes.
Commissioner Villanueva?
Yes.
Commissioner Villanueva?
Yes.
And Commissioner Williams?
Yes.
And chair votes yes. The resolution is approved. Does anybody need a break, or are we okay taking our individual ones given where we are? Everybody seems okay.
Okay.
So let's move on to item number 4. Gentlemen.
Chair Lang, I'd like to hand this item over to General Counsel Boyd to discuss the rulemaking that again will travel along with the proposed code of ethics with respect to expedited or informal advisory opinions.
Thank you. Go ahead, Walker.
Thank you, Director Ferris. Chair Lang, the memorandum that I sent to the commissioners and the proposed changes to 1.8.1 NMAC essentially gives the general counsel the authority to issue what I have called expedited written advice. This is kind of in response to a specific request I received from the general counsel for the Republican Party of the state of New Mexico, Carter Harrison. it's also modeled on what I've seen in other successful state ethics commissions, in particular the Indiana Office of the Inspector General. Basically, folks need answers to election law issues and other issues relating to the statutes that the commission has jurisdiction to enforce on a quicker time frame than the commission is able to provide, given its current bi-monthly, but even on a quicker time frame, monthly meeting schedule. Basically, people want to know within a couple of days whether some specific arrangement is problematic from the Ethics Commission's perspective. And what the proposed amendments to 1.8.1 NMAC accomplish is allowing the General Counsel to offer informal opinions about an ethics issue to someone on request. The request and the answer would be confidential. The important thing to note about this is that it would in no way bind the commission in any future proceeding. The commission is free to disregard the advice in deciding whether a violation has occurred. If on review the executive director determines that the informal advice is either incorrect or should be changed, he can do that, and the commission can then adopt something different. So really, the only thing that this does for the requester is it gives them a good faith defense to a later either a sort of independent proceeding brought by the commission itself, or by if something becomes a formal complaint. They can say that they received informal advice from the General Counsel that this transaction or arrangement was permissible under the law, and therefore they should not be held liable for violating the Governmental Conduct Act or the Financial Disclosure Act because they relied on that advice. So that's really the incentive that folks have to seek advice. And I had I had a couple of interactions with the Office of the Inspector General in Indiana. They say they're very happy with the kind of corresponding arrangement they have that allows their General Counsel to issue these informal opinions. They say that they answer hundreds every year, and that it's probably one of the more valuable services that the Indiana State Ethics Commission provides. I think that what this does is, again, it helps people. It gives people an avenue to seek advice that isn't necessarily the avenue of a formal opinion. The formal opinion does bind the commission, and so that may be attractive to some parties. But for state employees who just need a quick answer to something, this would provide them that avenue. And the reason that there's a proposed change to the administrative code is that under the statute right now, formal opinions are referred to in the singular, and there is no provision for this kind of informal advice. And so the administrative code provision that is in your meeting materials, in particular 1.8.1.10, sets forth what the scope and features of expedited written advice would be. So that's the presentation on the substance. As Director Ferris mentioned earlier, this would be considered on the same time frame that the commission would be considering the rules that would be adopting the model code of ethics. So for today's meeting, really the purpose of describing this and setting it out for the commissioners is to solicit feedback and draft a rule that the commission is comfortable with adopting at the June meeting for publication, for notice and comment, and then formal adoption.
Thank you. Commissioner Baker?
Yeah, I have a question. The last sentence of paragraph A says the request and the General Counsel's advice are confidential. I appreciate that the commission can keep the request confidential. How confident are you that your advice will remain confidential?
Chair Lang and Commissioner Baker, that would depend on potentially two things. One, the requester obviously could release the advice and would be in a position to waive any confidentiality with the advice. That's similar to how the commission already treats administrative complaints. The commission keeps them confidential, but the complainant and the respondent are not so bound by the State Ethics Commission Act. The second piece of this, obviously, is that someone could file a request to inspect informal advice, and the commission would have to make a call on whether to keep that confidential under this provision of NMAC. And if the person who filed an IPRA request brought a lawsuit, a court would have to determine the validity of this provision and whether it's a valid exercise of the commission's powers under the State Ethics Commission Act. I believe it is.
My concern is that somebody is going to be genuinely on the edge about whether doing something is appropriate or not appropriate. They're going to ask you for advice. You're going to give them the advice. And if you say that what they propose doing is appropriate, they're going to waive it and say, look what Walker Boyd put in writing. I'm okay with this. And I don't know that that's necessarily a bad thing, but I think potentially problematic. Puts a lot of pressure on you to get it right within a very short turnaround time. And what I'd like to know is, and I appreciate that other states have said this is one of the most valuable things they do, but if you can get examples of when perhaps it's been abused, that might help me a little bit in terms of this needs to be tweaked in terms of the way it's written.
Chair Lang and Commissioner Baker, I would note that any answer to a request for informal advice would contain a kind of disclaimer that says that it's based on what has been revealed in the request, and that if there are additional facts or issues that are not mentioned or that the general counsel is not aware of, then that could cause any advice in the response to change. So that's the first piece. The second piece is that I think that by keeping the executive director out of it and by keeping the commission itself out of the request, I think that limits the exposure that the commission has to giving its stamp of approval to an informal request. This would just be on letterhead from the general counsel saying, based on what you've told me, I think here's what I think the law is. And if the executive director reviews the request or an administrative complaint comes in that causes the commission to reconsider, the commission retains full sort of freedom to reconsider the general counsel's advice. And really the only effect of that advice would be to give the requester a kind of good faith defense.
This is hypothetical, but would you envision yourself drafting a response, showing it to Jeremy, and saying, what do you think? And then Jeremy, his fingerprints are on it. What happens then? I'm just trying to think about problems that could occur.
Chair Lang and Commissioner Baker, I think that's certainly permitted under the current setup. I think that the executive director and the general counsel, I think the State Ethics Commission Act contemplates them working together in terms of just operating the agency as a whole. Obviously, the executive director and the general counsel have separate roles with respect to handling the formal complaints. But as you've seen with the advisory opinion that the commission just issued, we have a collaborative relationship, and I do anticipate working with Director Ferris on informal requests for informal opinions if the commission ends up adopting a rule like this or a similar rule. I think again the fact that the rule and any advice issued would only have my signature on it, I think protects the executive director from being bound by any of the opinions that are set forth in the informal advice. And so even if there is some consultation that happens, ultimately it's going to be my signature at the bottom, or the general counsel's, any later general counsel's signature at the bottom of the informal advice, not the executive directors, not the commission chairs, no commissioners.
Chair Ling and Commissioner Baker, if I may, what having the general counsel here alone effectively does is, I don't really anticipate this being a problem with Walker and I, who work together very, very well and are on the same page. But in the future, for future executive directors and future general counsels, having the separation here allows the executive director to go into a commission meeting and tell the commission, look, the GC has issued advice. It's probably not right, or it at least needs to be looked at, and the commission could then be in a position to reconsider an informal opinion. To tie the executive director into this stage of the issuance of informal or expedited review would mean that it would be harder for the staff to bring a particular problem with an informal piece of advice to the commission. The executive director would have to kind of go and say mea culpa, which I have no problem doing, but future directors might. And then the commission would have to throw under the bus both the GC and the ED. And that's just different, different options that present themselves when, depending on how closely in you yoke the office of the executive director into this informal process.
And I appreciate that, and I agree with you. But again, this last sentence of paragraph A says the request and the general counsel's advice are confidential. So do you anticipate having on the informal advisory opinion, this is confidential, having a big red stamp that says confidential? And then when the requester shows it to a whole bunch of folks, there's no mechanism to enforce that other than, hey, bud, you were supposed to keep this confidential and you didn't. I'm just trying to foresee problems down the road and if there's a way to address them before they occur. But I appreciate what both of you have said. And I agree that a quick turnaround for a lot of questions is going to be very, very helpful.
Thank you. Commissioner Bluestone.
Thank you. Thank you, Mr. Chairman. Thank you, Walker, for bringing this to our attention. I'm especially interested in your discussions with the Indiana office and how this has really proved to be one of the most valuable things they do in terms of being able to give quick turnaround advice. And I think that could be the same here. And I like the idea a lot. But I do have two comments, suggestions, proposed changes, following up what Commissioner Baker was saying too. The first one is your memorandum talks about giving informal advisory opinions, which I think is an accurate description of what you're doing to draw the distinction between these informal advisory opinions and the formal advisory opinions that the commission itself can issue under the law. And I just think it would be clearer for the public in the rule itself to talk about them as informal advisory opinions rather than what you term in the rule as expedited written advice. I just think it's a little bit more straightforward to write the rules so that we draw a distinction between formal advisory opinions, which are issued by the full commission, and informal advisory opinions, which is what you're talking about turning around on a quick basis. To me, that's just maybe just a stylistic point, but I think it's just more straightforward and more understandable by the public. The second point is more substantive, and that concerns what Commissioner Baker was just asking about with respect to the general counsel just issuing these, although in reality, the general counsel working with the executive director in collaboration and discussions before they're issued. I actually think it would be more efficient and more straightforward also with the public to allow either the executive director or the general counsel or the two of them jointly to be able to be authorized to and to issue these informal advisory opinions. I think that, again, the goal is trying to get the best advice we can in the shortest period of time. And I think that I have total confidence in the two of you as individuals being able to work well together and come up with solutions. But I also think for the future, going beyond just you two as personalities, it is just always better to have two heads better than one as an option for working these things through. And I understand the concern that Jeremy also referred to in terms of insulating him from being on the paper, and that may having more of an impact in terms of allowing him to go to the commission to say that, well, actually, we think this was wrong. But I think that the real distinction is between the commission as a body, which issues the formal advisory opinions, and whatever you and or the executive director together would be issuing as informal advisory opinions. I still think we have the protection of the full commission to reach a different conclusion if that's what the commission later decides to do. So I'm saying I like the proposal. I think this could prove to be extremely helpful. I know from my years of experience at the Attorney General's office that so many people were so frustrated that opinions took so long to get issued. And to have the ability to turn things around very quickly, I think will be very well received and very helpful to the public. But I would like to recommend that we revise the rule to talk about them, as your memo does, as informal advisory opinions rather than this term expedited written advice. I think the formal advisory and the informal advisory is a more direct way of doing it. And I personally am more comfortable authorizing both the executive director and the general counsel, either separately or jointly, to issue these informal advisory opinions. Thank you.
Chair Lang and Commissioner Bluestone, thank you for those helpful comments. Certainly, whatever the commission's feeling is on what it ultimately chooses to issue, or the staff is going to be more than happy to abide. And I think that those changes are perfectly sensible. I would only, by way of response to the nomenclature issue, I think that the reason that the rule was drafted to discuss, to sort of talk about expedited written advice instead of informal advisory opinions, was to address Commissioner Baker's concern that so the requester is going to wave around whatever they receive and say, I've got an opinion from the State Ethics Commission that says that what I'm doing is perfectly permitted. And so that was kind of my my PC way of trying to phrase this as something that's more tenuous and subject to change than a formal advisory opinion. And so that was the explanation behind the choice of words in the rule itself. I do concede, as you point out, that as a practical matter, what this is issuing an informal advisory opinion. But that was the reasoning behind calling it expedited written advice, and whatever the commission's feeling is on what to call it, that's perfectly fine either way. And again, we've already covered the reason that the rule as drafted excludes the executive director, at least formally. It's that the commission has the opportunity to change whatever the general counsel's advice is. But certainly if the commission feels that the executive director and the general counsel should both be involved, I'm certainly more than happy to have Jeremy involved in this process. So.
Thank you.
Thank you.
Mr. Chair, can I jump back in?
Yeah, sure, Jeff.
Is it really important that the request and the advice be confidential?
Chair Lang and Commissioner Baker, the Indiana process does keep these requests confidential. I think that may be I think there are certainly folks who are going to be wanting to get advice and not wanting their request or the advice to show up on the commission's website. I think Jeremy can probably speak to this better. I think there are folks, members of the public, who call and state employees who call and want to get advice, and they want to do it in a way that's less formal, and it's not, and they don't want to have something that they wave around and say they've been talking to the ethics commission about this. They genuinely see it as a kind of a hotline type thing. But those are my only thoughts now, and I don't know how the process will unfold if the rule is ultimately adopted and we do begin issuing informal advice.
Chair Lang and Commissioner Baker, I think that we need to retain a confidentiality obligation that's binding on the commission staff. Otherwise, we're at risk of backdooring the statute through our rulemaking. We don't want to issue a rule that's inconsistent with the statute. So, I mean, perhaps this sentence needs to be redrafted to make it clear that a confidentiality obligation remains on the commission staff and the commission with respect to these kinds of requests and these kinds of advice.
Okay, thank you.
That makes sense to me. I'm just always a little concerned about balancing various rights. Obviously, the Inspection of Public Records Act is a big deal for very good reasons. And anytime we put the word confidential on something, it raises a red flag.
Thank you. Commissioner Carruthers?
Mr. Chairman, on the confidentiality issue, I'm fine with the way it's written. If in fact the person or persons asking for the advisory, informal advisory commission or informal advisory opinion decide to go public with that, it will not constitute the first leak of public information in New Mexico, to my understanding. And I think that that's not something I would concern myself more than about 23 seconds. The other thing is you need to reduce the number of days from receipt of request to issue the opinion to more like 30 days. There's nothing more disturbing about being a public servant and having to wait to 60 days with an extension of another 30 days to get an opinion, which may frankly only take, in some cases, I think in the Indiana case, 1 to 2 days to do. We're trying to expedite the situation here, being, of course, diligent in how we do it. We're trying to give people information as quickly as possible to make a decision. In 60 days in the public sector, as you can see what's happening to us today in COVID-19, 60 days is a long, long, long time. So you need to reduce that to 30 days.
Chair Lang and Governor Carruthers, the 60-day time limit is just copied from the State Ethics Commission Act. That's the number of days that the legislature set out as our deadline for issuing formal advisory opinions. And that is the one other thing that I neglected to mention that this rule does. It basically, it copies and pastes the provision of the State Ethics Commission Act dealing with advisory opinions into the rules so that the commission has a corresponding administrative rule for formal advisory opinions, so that the informal part can kind of mirror, or not mirror, but sort of relate to that. Certainly, it's the hope that if we begin issuing informal advice, that the commission staff would be turning around requests in just a couple of days. We would not be waiting 60 days or even 30 days to issue informal advice.
Mr. Chairman, members of the commission, I think this is a very important addition to the responsibilities of the commission. I'm very supportive of this particular set of amendments.
Thank you, Commissioner. Commissioner Solomon?
Thank you, Mr. Chairman. Walker, I was just wondering what volume of requests for these informal advisory opinions we're seeing now. Are we in a situation where we're getting, voluminous requests every day, or are we just anticipating that we'll be getting these kinds of requests? Thank you.
Chair Lang and Commissioner Solomon, I fortunately do not man the switchboard in the State Ethics Commission office, so Sunny and Jeremy are probably better placed to speak to that question.
Chair Lang and Commissioner Solomon, yes, we do receive requests for advice, but really in the form of inquiries into the Commission's formal advisory opinion process. So I've received several calls from other members of state agencies asking how they would go about requesting a formal advisory opinion. And once they're informed as to how it happens and how the Commission meets every other month and in the 60-day provision, those inquiries haven't been followed up with actual formal advisory opinion requests. So, today the Commission just issued its second formal advisory opinion, but we've had a fair number of inquiries into advisory opinions that's larger than 2.
Thank you.
Thank you. Commissioner Villanueva?
I just have one question, Mr. Director. Can you foresee that the request for advisory opinions will come to the point where we would have to prioritize them? Would there be a prioritizing method for dealing with informal and formal requests for advisory opinions? Would one be more important than the other?
Chair Lang and Commissioner Villanueva, yes, the formal opinions are more important. They're more important because they can be relied upon by the requester in a subsequent administrative proceeding in the Commission. It kind of provides a kind of defense for the requester. And the formal opinions are issued by the full Commission. They're more formal, they're more weighty, they have other legal effects. The informal opinions are just providing a guidance function to other members of the state and other members of the public on a kind of rapid basis. It is very possible that not only this particular process that we're developing, but also through the administrative complaints, that we become overwhelmed, and that the Commission will need to have to prioritize between what it views as more weighty requests, more significant requests, and more significant complaints even. We are operating on a skeleton crew. We only have budget for four people, 3 on board now. And it's very possible that both in terms of requests for opinions and guidance and complaints quickly kind of outpaces our ability to handle them, and we'll need to prioritize.
Thank you, Mr. Director.
Mr. Williams? Commissioner Williams?
Yes. I think I'd like to propose or ask the question, shouldn't we have a disclaimer here which would say that this informal complaint cannot be used as evidence in a formal complaint, that our decision informally cannot be used in a formal complaint, and have a disclaimer in this proposal?
Chair Lang and Commissioner Williams, I'm happy to let Walker respond more fully, but I think it makes sense for these pieces of advice and guidance to indicate that they are not the formal advisory opinions issued by the Commission. That's a separate document that's separate from what's being issued.
Chair Lang and Commissioner Williams, the only thing I would say is that the current rule as drafted gives folks who request informal advice the ability to use the informal advice as a kind of way to say that they were acting in good faith if their conduct later becomes the subject of an ethics complaint. And so in that respect, the informal advice would be evidence in a later proceeding under the current rule. And I do think it's a helpful incentive. It's probably the only incentive really we can offer beyond the advice itself. That is, that if you come to the Commission and ask for the Commission's advice, and the Commission says, and the General Counsel says, looks like this transaction complies with the law, and that you then later become the subject of an ethics complaint, then you can at least say that I was acting in good faith, that I reached out to the commission staff to determine whether what I was doing was legal, and therefore I shouldn't be sanctioned for something that's become the subject of a formal complaint.
Well, I didn't think in terms of any sanctions, but if I was going to file a formal complaint and then I had this advisory informal information from you, I would be very prone to use it as part of my evidence in presenting my formal complaint. So that was my question. If you give me an informal opinion and then I decide to file a formal complaint and I include what you said in your informal advisory, I mean, is that permitted? Or should we have a disclosure that says, well, you can't use this as a platform to file your formal complaint?
Chair Lang and Commissioner Williams, the proposed rule says that, and this is subsection B, 1.8.1.10, if the commission determines that a person committed a violation after reasonably relying on the general counsel's expedited written advice, and the violation is directly related to the general counsel's advice, the commission may consider that the person acted in good faith. And so really the only situation that the informal advice would become relevant to a complaint would be if someone had that advice at the time they committed a violation, and they relied on that advice at the time they committed a violation. So I don't see the informal advice being used offensively by someone who later makes a complaint. I see it being used only as a defense to a complaint. But I'm open to change my mind if I've missed something. So
thank you.
Thank you. All right. It appears as if I think we need a formal motion and adoption. Is that accurate, gents?
Well, Chair Lang, what I would suggest, it is listed for an action item on this agenda, but I would actually suggest that you give Walker and I an opportunity to go back and make some of these changes. And since at the next commission meeting, the commission will be issuing a number of rules for public comment that we just kind of carry this over to then.
Right, and in the meantime, we will see the product of your judicious editing.
And any other commissioners who want to chime in on this rule can contact Jeremy or me directly.
Yeah, I like that because I think there is some tinkering that has been suggested and everybody seems to be on the same page with. So, all right, thank you. Next, we're going to hear from Sunny.
Yes. Next, Chair Lang, Mr. Haqqani has completed a very long piece of research on the initiation of administrative complaints and ethics commissions around the country. And this is responsive to Commissioner Carruthers' inquiry about the notarization requirement on our administrative complaints and other options. And so I'd like to turn it over to Sunny to present his research.
Thank you. Good morning, Sunny.
Good morning, Chair Lang. Director Ferris, can you hear me?
Yes.
Okay, great. Thank you, Director Ferris. Chair Lang, Commissioners, I would just say that this is, to remind everybody, this research was conducted in response to Commissioner Carruthers' request that commission staff look into notarization requirements of other state ethics commissions. So I did a survey of all the other states that have ethics commissions and looked at their requirements for how the formal complaints are initiated, what the requirements are. And the document itself contains a brief summary of each one and a very helpful table in the first few pages that kind of clearly shows that there's a variety of results, really. 29 commissions require notarization, and 19 of them do not. And so there's quite a bit of variety, and each one kind of lays out, the initiation requirements and then the penalties, if there are any, for bad faith complaints. And between those two pieces of information, you can get a sense for how these commissions are kind of balancing complaint volume. With that, I would just add that it's because of the our commission's low volume of complaints right now, it's probably premature to make a recommendation on whether or not to include or exclude the notarization provision from or from future statutory revisions. But that being said, it's very clear that this has been done successfully both ways in other state commissions, and in many cases there are very creative very creative commissions that use alternate processes, very similar to our resolution number 4 that was just passed, which the commission can, get information from a source that's not a notarized complaint and still take action on it if it's an important enough issue. And so with that, I open to questions.
Thank you. Commissioner Baker?
I don't want to get too far afield. Brian McHale from the Philadelphia Board of Ethics is a public attendee. I don't know if it's appropriate to ask him if he has any anecdotal information about what they do in Philadelphia in terms of, or in Pennsylvania with respect to, is notarization a problem? Is it a roadblock to people making complaints, or is it essentially a non-issue?
I just unmuted Mr. McHale.
Commissioner, I'll speak from the perspective of Philadelphia rather than the state of Pennsylvania. Notarization has certainly not been an issue for us as far as beginning an investigation or an adjudication. In fact, there is no notarization requirement in anything that we do. And that's also true for, we also oversee campaign finance reporting. We do not require a notarization, unlike the equivalent report that goes to the Commonwealth of Pennsylvania, which does. What we need, as far from an investigative perspective, is that we need a complainant to tell us who they are, and that's pretty much it. We just need the information necessary to interact with them and move the investigation forward. And so we just have a report a concern button on our website, which people can fill and file a formal complaint with us.
Thank you, Mr. McHale.
So if I understand, the state requires notarization, the city does not require notarization. And is there a way to tell if one has been more effective, created roadblocks? Are you getting more garbage complaints than the state?
I mean, from my perspective, I would argue we have not received much garbage. I mean, there are certainly situations that come in which either do not fall under our jurisdiction, or just on its surface we can make an initial determination is not a violation of any of our laws. But the lack of a notarization does not result in more junk from my experience, and quite frankly, we would rather people be sending stuff in than not. Much in the same way as we'd rather people ask a question than not. And that to date has not overwhelmed us.
Thank you.
Thank you, Mr. McHale.
Thank you. Commissioner Bluestone?
Thank you. And thank you, Sonny, for the research. It's very helpful to see that you did a very thorough job. Much appreciated. Just curious, I assume that with the vast majority of states having the penalty of perjury for filing a false statement, is that a felony in virtually every state, if you happen to know?
The research showed that some states specify in their statute penalty of perjury and then clarify it as either, from a class B to, a class C misdemeanor. Some of them specify fines associated with that. Some of them specify criminal penalties. So it's kind of mixed, but I found that less commissions statutes specify it as a misdemeanor than just penalty. Penalty of perjury is kind of the general standard. Even for commissions that don't require notarization, the general specified penalty is penalty of perjury.
And I think the general specified penalty of perjury is a 4th-degree felony nationwide. And I'm seeing our chair, Judge Lang, nod in agreement.
Yes, that's my understanding as well.
Thank you.
Anything else?
That's all.
Okay. Thank you. Commissioner Carruthers.
Mr. Chairman, thank you. Sonny, thank you for your good work. You did exactly what I was looking for. I guess my question would be, if we don't notarize, you can still perjure yourself. Is that correct, by just signing it?
That would be what other commission statutes and or what other state statutes and other states commissions suggest, is that, if the commission accepts a complaint from a person that was made in bad faith, they can still perjure themselves.
So just given the inconvenience of trying to find somebody to notarize something, I happen to know people who do this kind of work, but a lot of people don't. And so finding somebody to notarize can be somewhat of a restraint or constraint to people filing.
Mm-hmm.
Why wouldn't we just look at the perjury side and say, if you signed the darn thing and you did it not in good faith and you perjured yourself,
right,
there are some consequences for doing that, and get rid of the notarization.
Certainly, and Chair Lang and Commissioner Carruthers, there are many other commissions that do precisely that. There are some, I would point you to California. They explicitly state that complaints have to be signed and notarized. In the statute, it says signed and sworn. The commission interprets this as a notarization requirement, but then they also provide the opportunities for complaints to be made anonymously or have the complainant's identity withheld with good cause shown, and that determination is made generally by the general counsel of or an attorney at the California Commission, their Fair Practice Commission. So it's kind of within the discretion of the commission whether or not to make that call. But
Chair Lang and Commissioner Carruthers, if I may, if the notarization requirement were statutorily removed, that under the statute there already is a penalty of false statement provision, and that would just remain in the statute. So notarization would remove the administrative sludge hurdle that you pointed to, but so long as we touch nothing else in that provision, the penalty of false statement would still be there. And I would not recommend that the commission invite further amendments to the penalty of false statement provision. There was a lot of debate about that particular topic in different bills, and it almost torpedoed the State Ethics Commission Act's passage 2 sessions ago. So I think any changes that we make to subsection B or recommend to subsection B of the statute need to be done very, very gingerly. And I would also point out that I think that any amendments that we would recommend to this statute would be a heavy lift. The 10B was a product of great compromise and negotiation in the legislature 2 sessions ago. But just to put a bow on it, if the notarization requirement were removed, there would still be a penalty of false statement.
Mr. Chairman, Jeremy, thank you very much for that. I am going to continue to be concerned about it, but I think I'll take a look at our informal processes and see if in fact that citizens feel that there is a different avenue if they're concerned about having to file a complaint and sign it, or if we can, as you said, read about it in the newspaper and decide there might be a violation of the code of conduct or something. But we just need to free it up so more people will feel that ethics is being considered a serious issue in New Mexico. And so I'll continue to be concerned about notarization, but if our informal processes prove out to allow people another avenue, then perhaps I could be a little quieter on that subject.
And Commissioner Carruthers, the resolution 4 that the commission just adopted significantly frees the commission up to respond to any kind of source of grievance that we receive.
Thank you.
Chair Ling, or I'm sorry, if I may, Chair Ling, Commissioner Carruthers, I would, double down on what Director Ferris just said. When I looked at all of these different commissions, the golden ratio, the golden balance there was a commission that kind of like had a notarization requirement, but then too slow, potentially bad complaints or too many complaints that were made improperly, but then simultaneously the ability for the commission to take its own action on very important issues that a notarization may present a barrier. And so I think with the passage of resolution 4, we've kind of hit that perfect golden ratio there.
Thank you. All right, Commissioner Solomon.
I have no further questions, Mr. Chairman.
Thank you. Commissioner Villanueva. Commissioner Villanueva.
Hello?
Yes.
Okay, I'm unmuted now. I'm sorry.
There you go.
I just wanted to note on the fine work that Sunny did that there are at least 7 states that impose a penalty for perjury that do not require notaries.
Right. Thank you. Commissioner Williams.
My only question or clarification is that if we wanted to propose that there is no necessity for notarization, wouldn't that require an amendment to the statute that does require it?
Yes.
So we would have to recommend that to the legislature, that notification or notarization process be eliminated.
Well, whoever recommends it, yes, the legislature would need to amend the act.
Okay, so are we going to do that, or are we just going to require that the notarization continue?
Well, any complaint, Jeremy, you can speak to this, but it seems to me that until that is removed, any formal complaint from outside of the commission would need to be notarized.
Chair Ling and Commissioner Williams, I recommend that we drive the car a little farther down the road and get a little bit more information about how we're receiving administrative complaints and the volume, and also just kind of now begin to test drive this other car that we've let out of the garage with resolution number 4.
Thank you. I do want to compliment you, Sonny. You did an incredibly good job. Even I understood it. Thank you.
And even I understood it. That was, I would echo the sentiments of my fellow commissioners. Good work, Sonny. Thank you. Okay. Shall we move on now to entertain a motion to go into executive session?
So move.
Second.
All right.
Chair Ling and commissioners and members of the public, what we're going to do now is the commissioners and the staff are going to move into a breakout room in Zoom. And we will leave this room open so that members of the public can remain in this room. And when we return from executive session, you'll see us come back, hopefully.
Jeremy, I need to take a vote to make sure that the motion has passed, okay?
Thanks, Judge Lang.
Commissioner Baker?
Yes.
Mr. Bluestone?
Yes.
Mr. Carruthers?
Yes.
Commissioner Solomon?
Yes.
Commissioner Villanueva?
Yes.
And Commissioner Williams?
Yes.
Thank you. Chair votes yes as well. Okay, Jeremy, go ahead and do what it is you need to do.
Okay.
I am creating breakout rooms right now. It'll take me just a moment to move everyone into the appropriate room. Yeah, so. All right, looks like we have returned and all of the breakout rooms are closed. So we're back in public session, folks.
Okay, thank you. We are now returned from executive session into public session. Jeremy, go ahead.
Thank you, Chair. When we were in executive session, the commission acted on administrative complaint 1, and the motion was to approve an order of dismissal of administrative complaint number 1, and having discussed that in executive session, the commission needs to act on that motion now that we are back in open session.
All right, thank you. Is there a motion and a second? Thank you, Commissioner Baker. Commissioner Baker?
He's on mute. Oh, there he is.
Okay. Yes.
Commissioner Bluestone?
Yes.
Commissioner Carruthers?
Yes.
Commissioner Solomon?
Yes.
Commissioner Villanueva?
Yes.
Commissioner Williams?
Yes.
Chair votes yes as well. Motion carries unanimously. Next item.
Chair, the next item is the determination of the next commission meeting. At the last meeting, it was decided that the commission would decide meeting by meeting whether or not to stay on the every other month of the first Friday of the month, which would make the next commission meeting June the 5th, Friday, June the 5th.
What staff recommendation you had indicated? We've talked about a couple things today that were going to be worked on, and as well as requiring some dissemination for public comment. So I assume that June 5th is what staff would be gearing for?
That's correct, Chair Lang.
Okay. Let me ask the other commissioners, anybody have a sense that we should deviate from that, at least at this time?
Mr. Chairman,
Yes, Governor.
I think the regularity of being able to schedule every other month at a certain time makes it much more convenient. I know we're all isolated now, but when I came up with this idea, we didn't have the conditions we have today, but at least I can get it on the schedule and anticipate doing something. It gives the staff some kind of routine to anticipate that every couple of months they're going to have to visit with the commission. So I continue to favor the schedule that was recommended.
Thank you. Does anybody have a different opinion?
I have a different opinion. I think with the volume of work that is coming to the commission, I think that it is more appropriate to hold the meeting once a month, because I think things are going to get busier. But I think that with that, we should hold the meeting once a month.
Okay. Commissioner Baker, what are your thoughts?
Well, I think at the moment, I'm going to defer to Jeremy and Walker and Sonny in terms of their workload and when they can be ready to effectively meet with us. And if after June 5, everything needs to accelerate, we have the option of doing that. So I would just say, let's do June 5, and we can always revisit.
Commissioner Carruthers, you've checked in on that. Commissioner Bluestone?
Yeah, I think it makes sense to just stay open-minded, as Commissioner Williams is suggesting, if we need to meet more often than once every other month. But I think for now, let's continue to schedule just our next meeting for 2 months from now on June 5th. And at that point, we'll revisit and decide what we want to do. But I like the idea for now of assuming that until the workload changes, that this every other first Friday is an appropriate setting for us to go forward with.
Commissioner Solomon?
Well, I was looking at my calendar, Mr. Chairman and colleagues, and I was going to be in Greece on that day, so I have nothing better to do than attend a meeting on June 5th.
Yeah, I'm guessing not. Yeah. Commissioner Villanueva?
Yeah, I have no feeling either way.
Okay, thanks. Yeah, my preference is to stay with this, that we will assume then that we'll go with the every other month Friday, and if one of those meetings we come up and we agree, the consensus is that we should have meetings more regularly, or at least have one extra meeting. We can deal with it at that time, but otherwise let's plan on the every other first Friday. So the every other month first Friday. So the next meeting will be June 5th at 9 a.m. Hopefully it will be at the offices, but we shall await further direction from the COVID-19 virus as to where and when where we will meet. The next matter is public comment. Jeremy or Walker, whoever's driving the bus today, the electronic one, you figure out how that happens.
I'll take it, Judge Lang. So for members of the public, we're now moving on to public comment. So if you would like to make public comment, please raise your hand through the Zoom application. If you're on the phone, I believe it's *9 to indicate that you would like to make a comment. And as people raise their hands, I'll go through and unmute you and allow for the public comment. And I see that we still have several members from the public in the meeting, so I anticipate that you've waited this long to participate in public comment. So we'll start with State Auditor Colon. Thank you for joining us, and you're unmuted.
Good morning, Chairman Lang, members of the Commission, Mr. Executive Director and team. Thank you for allowing me to initiate some public comment here. I would just want to let you know that I was on today along with my Director of Constituent Services, Antonio Corrales, and the reason I attended was just because of the importance and the gravity of the work you do, and it's important for me to be able to make sure that we continue to work together as governmental bodies and agencies, and you as a commission, to ensure that we are doing everything we can to restore people's faith in government. And I have had now at least 2 interactions with your team. Both of them have been incredibly professional. The correspondence coming out of the Ethics Commission, at least with my office, has been far superior than most of the correspondence I get. And I just want to commend you on that, applaud you on that, and tell you that the Office of the State Auditor stands ready, willing, and able to work with you in all ways that are appropriate, and really wants to validate the work you do. I travel around the state and speak to stakeholders on a very regular basis, not in person, of course, right now, but as I do travel the state, I will continue to applaud your work and discuss the importance of your mission to restore people's faith in government and hold individuals and entities accountable. So I just wanted to add that today. Thank you, Chairman Lang, for the opportunity to do that, and thank you to the commissioners for your great work, and the staff and team at the commission are just continuing to do great work on the front end.
Thank you, Auditor Colon. And I'm going to mute you back and lower your hand. I believe that Tony Ortiz, if you're still the unidentified iPad, you're unmuted.
Thank you, Mr. Director and Mr. Chairman and Commissioners. I'd just like to echo the comments of Mr. Colon that really take heart at the professional and really strong job that you're doing in getting this work underway. Very briefly, recently, Common Cause and New Mexico Ethics Watch recommendations for statutory changes to the Campaign Finance Act and the Lobbyist Regulation Act. And at some point in the future, we'd really appreciate an opportunity to come before the Ethics Commission and share our thoughts and give you a little bit of context for the work that went into developing those recommendations. So In closing, stay well, be safe, and thank you.
Thank you, Mr. Ortiz. Is there any other members of the public that would like to make public comment at the time? I don't see any other hands raised on Zoom. Perhaps that's because members of the public are unsure how to do that. Sunny, would you chime in and give a few pointers on how members of the public might do that if they wish to? Let me unmute you, Sunny.
Okay, great.
There you go.
Was the question of just how they can indicate if they have a public comment?
How to raise the hand on Zoom if they don't know how.
If they don't know how. Pressing *9 on your keypad will tell us that you would like to make a comment. It'll put we'll receive it as a blue hand icon next to your name.
Okay, thanks, Sunny. Okay, Chair, I see no other public
Tony,
comment.
what about computer users or iPad users?
If you're on your computer, you can press the Participants tab, and at the very bottom of the Participants tab, you'll see a small button to raise hand. And the Participants tab is located at the bottom. If you're using a desktop, if you're using an iPad, it's typically up in the top right corner.
Okay, I see no other comment, Chair, and I believe we've made it through our first virtual meeting without being Zoom bombed.
And guys, you did a phenomenal job. This was as seamless and as painless as these can be. I've done some private work on it, and it's clumsy, and that's operator error, I'm sure. But thank you guys so very much for setting this up, for educating all of us. Obviously, it worked, and some of us are less educable than others on matters computers. So really, thanks. Well done substantively and mechanically, if you will. Anybody else?
I would like to second that. And really, I am a very technically incompetent person. I had some help, but this was really my first adventure in Zoom, and I enjoyed it. And I would like to leave a thought with the public and the commissioners, which was said by Martin Luther King. And he said, morality cannot be legislated, but behavior can be regulated. Judicial decrees may not change the heart, but they can restrain the heartless. Have a good day, everybody.
Thank you.
And a good week.
Anybody else? Commissioners, anybody else want to say anything?
Mr. Chairman, move adjournment.
Yes.
I move adjournment.
Thanks. It has been moved. It has been seconded. Commissioner Baker.
Yes.
Commissioner Bluestone.
Yes. And thank you,
Commissioner
everybody.
Hubbard.
Yes.
Commissioner Solomon.
Yes.
Commissioner Villanueva.
Yes, and thank you so much for doing such a good job with this.
Commissioner Williams.
Yes.
Chair votes yes. Thanks again, everybody. It's good to see everyone. Please stay safe and healthy. And
Please.
see you next time.
I'm going to end the
Thank
meeting.
you.
Thank you, everybody.